In addition to these two basic theories of the origin of laws, we must keep in mind that there are laws, rules, which are merely conventions, and they can come in two forms. The idea of positive laws, or the necessity for positive laws, comes from the necessity for practical social order. Some positive laws do not seek to enshrine justice, but merely to provide some practical ordering for society. It goes back to the idea of you've got a lopsided ball, are you going to play rugby or AFL with it? No point in having one team playing rugby and the opposing team playing AFL. They simply won't be able to make sense of what's going on. And so we have to put a set of rules that everyone's going to play by in order to be able to have some sort of order. Neither is good or bad. We've mentioned driving on the left in Australia as an example, but also our habit in Australia of using Australian dollars for our commerce is a positive law or a positive convention. The age limits that we choose for driver's licences and buying alcohol. Why is it 18, not 16, not 21? It used to be 21 and it's come down to 18. Will it go down to 12 in a few years' time? We don't know. However, there is some prudence in making these arbitrary rules, these positive rules, positive laws, in order to have things run better. Even little things like, signs in buses and trains saying, don't put your feet in the seats. Penalty $20 or $50 or $100 or whatever it's going to be. They're useful because it simply saves the community from having to spend a lot more money on cleaning seats and just the inconvenience of future travellers having to sit on a seat which is covered with mud from some previous owner, rider on the train. Okay. In themselves, positive laws have no inherent value. Why do we drive on the left and not on the right? Well, who cares? Some countries on the left, some on the right. It'd probably be handy if internationally we all drove on the same side, but for whatever reason we don't. There's no good or bad about that. Whether we trade in gold bars or Australian dollars, again, no moral value. You're not a bad person if you use barter in Australia or American dollars if everyone was inclined to do that. In some countries you do find the local currency plus USD, and that works for whatever reasons. Generally, positive laws have no inherent moral value. We can see that fairly clearly. However, they often have punishments for disregarding them. And what that means is that if you do disregard them, it doesn't make you bad, but you have to accept the punishment, assuming the law comes from a licit authority. If I drive down some back street at 60 kilometres an hour, but it's only supposed to be 50, am I a bad person? I don't know if the greater probability of bumping into somebody is that much different between 50 and 60 or 40 and 50, whatever it is. However, I might be breaking the law because it might be a 40-kilometre zone or whatever it's going to be. And if a policeman sees me, or I get caught in a radar trap or something, I have a fine to pay, a punishment. And so I discharge my moral obligation to the society by paying the fine, whatever it is. I become bad if I run away or do some silly thing to avoid paying the fine. And so there's a kind of a moral overtone to positive laws if they're not respected in some way, shape or form. But as far as driving 70 kilometres an hour down a 60 kilometre an hour road, it doesn't actually make you a scoundrel or, irresponsible person. That's a curious question because the speed that you travel down there, it can verge on being immoral or naturally unjust if you, let's say, go down a 50 kilometre hour road at 160. merely because at that speed you're probably unlikely to be able to avoid accidents and so on from someone reasonably just turning into the road or pulling out of their driveway or something. And so there is this dimension to it. But overall, positive laws in themselves have no inherent moral value until they start to impinge on natural rights of the people about. They do intend, however, some indirect moral purpose. We've seen that with the no feet on the seats ruling. It's a positive law in itself, but its object is the convenience of the community in general, future riders on the bus or the cost of cleaning and so on. Now, largely we can say that the indirect moral purpose of our property title system is to protect the natural property rights of the humans that might be affected. The owner, visitors, Aboriginal people, all sorts of people might have natural property rights to what you call your property. And it's an interesting question to explore where the positive rights of the title systems we use actually impinge on those natural property rights that could possibly be being violated when you misbehave with respect to the positive laws. This gives a certain complexity to property law. Our dominant system in Australia are positive laws. We've adopted those laws as a result of history, largely. Conceptually, they're intended to support an orderly settlement and land use, and that's certainly the way that our colony and later our country was formed. And the idea was as benign, perhaps, as driving on the left-hand side of the road, although I don't think that was probably such an issue when we had horses and carts. And it protects the natural property rights, the indirect natural property rights of the people involved. We have inherited our property law system from England, English law. Now, that's not English law. It was practiced for the last several thousand years. It is really only the English law that developed roughly over the last half a millennia, from about the 16th century onwards. In Australia, we imported English property law when Captain Cook took possession of the continent of Australia and incidental islands around it like Tasmania. In his 1770 Act of Possession, that was carried out on Possession Island. Basically, he hopped out of his boat with a handful of sailors. They rowed ashore. The sailors all had rifles, most of them did, and someone carried in a flag on a stick, a rag on a stick as far as the Aborigines could see, a brightly coloured rag on a stick, but something that, while it didn't have any significance to the Aboriginals, it certainly signified the English crown. And so in 1770, the continent of Australia was taken for England by a representative of England in that particular ritual. It was simply an act, a few words said in English and recorded on paper and so on, and signified by the rag on the stick, the flag, the Union Jack. You'll be exploring the way that was based on the assumption that Australia was not previously owned by anybody. It was terra nullius, a empty land, a neutral and a vacant block. And that has been explored and questioned, especially in recent decades. That's Australian property law. We now find a second system of property law being recognised. Did it previously exist? Well, it seems that it did. Is it a property law system? Well, that was one of the questions. It's a fairly complex question. But it certainly was something that was understood by the indigenous inhabitants to have existence in a real and meaningful way, although not real and meaningful through the eyes of the English as they set ashore. There are some interesting, shall we say, complexities to that. Captain Cook, as he sailed around the coast of New South Wales, or the east coast of Australia more generally, there was one point in his log where he records the way that he was able to enjoy the sun setting behind the trees. Joseph Banks recorded also the same phenomenon. Why is that significant? Well, it's simply a natural observation about the way the sun was setting in amongst these trees. But it was actually curious because today, if you sail past the same part of the Australian coast, you will never see the sun setting through the trees. And the reason is there's considerable undergrowth that causes all of the forests to basically be opaque. The sun can't get through. Why could it get through back in 1770 when Joseph Banks looked out and Captain Cook, they wrote in the diary, ship's log, about this lovely sight? It was because the Aboriginals were involved in active land management, where they regularly burnt off the undergrowth amongst their forests. It was actually a very useful part of environmental stewardship. It served a number of advantages for the Aborigines, and it was carried out over defined areas due to the understanding of property and property management carried on by the indigenous people. The significance of that is that it meant that what the people in the Endeavour were watching or seeing was the effect of active property management, which happens when you do have an ownership system. It's one of the many facts that challenge the idea of terra nullius. However, while we might explore that in a separate topic, for the present, one of the most important and potent questions about the two property systems in Australia, the customary property rights system, is that it's based on a natural law argument. As you go through the readings and explore the different topics which we're going to be covering in this unit, you'll be able to interpret, especially if you're aware of the natural law, positive law distinction, of the way that what you'll be studying is basically like the rules of football, the rules of rugby, a set of positive laws with minimum attention to natural laws. By contrast, the Aboriginal people, the indigenous inhabitants of Australia, based their property rights arguments on a natural law argument. This is extremely important because it means that when Australian lawyers confront Aboriginal people, they're thinking in terms of a legal system which is a positive law system, not linked, grounded in natural law. But they're talking to Indigenous people, and the Indigenous people will immediately talk in terms of their relationship with the land, their property rights framework, based on a natural law argument. This is extremely important, and I do recommend that you give thought to it as you explore the complexities of the current attempt in Australia to reconcile these two different property law systems.